All right, that brings us to Amanda Roshan and Charles Roshan. I know Ms. Gilmore is here and Mr. Roshan is here. Let me ask you this. First of all, a lot of times when an attorney gets involved in this docket, we will put it over to a representative docket. And if you want to do that, we'll find you the first available time on a representative docket to handle these motions.
I honestly will defer to the court. If you feel like you have reviewed everything, I'm fine moving forward today. Alternatively, I'm happy to move it over to the attorney docket either way.
Okay. Well, I have reviewed it, and so I'm happy to hear from you. And
I would like to voice a preliminary objection.
Go ahead.
I did receive a reply declaration. I believe that was received to my office either on the 6th, Friday, or Monday the 9th. I don't have it actually in front of me. We would be objecting to the consideration of that reply declaration. It was untimely. It's lengthy beyond the court's rules, and it contains numerous new informations that was not contained within the motion itself. If the court looks to the actual motion, it is pretty thin and fails to provide a lot of additional information. And so then he supplements substantially. My client didn't have the opportunity to respond. We don't believe it's properly before the court.
All right, Mr. Roshan, what she's saying is it was filed on January 6th. Declaration was untimely and is asking the court to not consider it. Do you have a response?
Morning, Your Honor. Can you hear me well?
I can, yes.
Perfect. So it actually was submitted before the deadline, so I'd actually like to move forward.
Okay.
As the court's aware, sorry.
When was it submitted? Do you know?
I believe it was Friday, and I had it in the courthouse I turned it over about 11 or 12 p.m., but it was emailed over that same day.
It was the 6th that you submitted it?
I'm going to review my calendar just real quick. My email. Friday the 6th at
it was filed. Ms. Gilmore, I've read the declaration. To completely put it out of my mind is somewhat difficult. So I'm going to overrule the objection and I'll consider it.
Okay.
So we've got, I guess Mr. Roshan's asking for temporary orders at this point. And so do you want to address that, Mr. Roshan?
Yeah, Your Honor. I mean, bluntly, I want my belongings, I want my tools, and I want all my children's belongings. My wife has stated in her initial reply to me that she's returned everything. You yourself granted me a
civil standby.
Yes, sir. I was granted that, and I was given 15 minutes. And from your order, I was granted permission to take personal items, but I didn't have time. What I really needed was my sewer scope, along with my radon testing equipment for work. So that's what I was able to retrieve at the time. For me to be able to acquire my possessions is going to require like at least the better part of a day, probably close to 10 to 12 hours, but the use of my trailer, assistance with friends. I have way more than just what I'd be able to grab in 15 minutes. A little later down the road, on the 20th of November, my wife, Amanda, her mother, Irma Jenkins, met me in front of the courthouse in Castle Rock. And she had 5 or 6 boxes, small boxes, and 2 or 3 garbage bags that did contain some of my things, but it was mostly clothing and mostly items located in mine and Amanda's nightstands, up to and including numerous of Amanda's possessions, which I have bagged up and ready to drop off wherever. And then, of course, my children have furniture. They have their bed frames, their beds. Exterior wise, I've got chicken coops. Amanda's welcome to keep 2 of them, but I'd at least like my Cerama coop back. And then on the inside of the shop, the inside of the shop is full of tools that I use for my livelihood to make income while I'm not inspecting. I submitted a contract that I wanted you to review to show that inspecting is my primary income. Amanda's aware of it, has been aware of it since we jointly decided that this was going to be what I do. It isn't something that starts out successful overnight. It takes years to become successful. Since the separation, I have been called back by a secondary inspection firm that I'm working with to get a contract going, a second one that I'll be doing in addition to home inspections. I'm now going to be doing insurance claim property inspections. But for me to supplement the way that I really succeed at, I need access to my tools to get back into handyman work in the slow seasons. But for the meantime, I'm fine taking on more contractual work. The fact of the matter is I can't just run out and go find some source of employment. It has to be able to meld with my current contract. And then the underlying issue that it's got to meld with is my children's schedule. I make my kids priority 1.
Okay.
And then additionally, I just ask for fair division of equity by Washington state law, and for us to be able to move on with our lives.
All right, thank you. Ms. Gilmore, any response?
Yes, Your Honor, and thank you. For the record, Megan Gilmore on behalf of the petitioner and non-moving party, namely Amanda Roshan. This is before the court on husband's motion for a temporary family law order. As the court's aware, as explained within my client's declaration, the parties were in a short-term marriage from March 22nd, 2019 until their final separation on November 10th, 2022. So at this point, these parties have been separated for roughly 2 to 3 months at this point. My client was granted an order of protection by this court on December 5th, based on the longstanding history of domestic violence as well as physical abuse. We believe the husband brings this motion with the sole intention of continuing to abuse my client. Within the restraining order action, he was granted on 2 separate occasions access to the home by way of civil standby to access his work-related tools and personal effects. However, he has failed to do so. Out of interest and love for husband's children, my client voluntarily transferred a majority of their belongings, as well as allowed the children, along with their mother, to come to the home recently and access all of their remaining property relating to the children. So we don't believe there's any outstanding issues regarding to the property owned or associated with husband's children outside of this marriage. We believe that there is no immediate property concerns, and again, if they were, that there would be an issue with civil standby. Again, all of the remaining issues should be resolved by the parties by agreement or determined at the time of trial. It's not appropriate on a temporary orders hearing for the court to make rulings regarding equity of the home, division of retirement, etc. What I would suggest and what we typically do on the attorney docket is that if there is ongoing personal property items, smaller personal property item issues, the moving party would provide a detailed list of what the actual assets that he wants. I will review that with my client. My client is not trying to hold any property or deter him from working anyway. It's our, again, it's our understanding that he had access to the home at least once to obtain these immediate items. So I would ask for him to provide a detailed list of the assets that he wants outside of just general all things associated with myself. I will review that with my client. We'll work to get those properties returned to him in the interim, and then on presentation, if there's any disagreements, then that can be addressed and further ruled on by the court. But again, my client's happy to present detailed information, but she does have ongoing concerns about him just having free access to the home for 12 hours. Again, this is a domestic violence case. This is a restraining order case. My client's in fear of her safety, and it's not appropriate to have the person living in her home, I think her name was Megan, being kind of acting as a facilitator for this. So again, if there's any small issues, my client's happy to resolve them. Alternatively, they need to be resolved at mediation or trial based on more information. Looking to spousal support, this is absolutely not a maintenance case. These parties were married for just 3 years prior to separation. As set forth within Washington state case law, in a short-term marriage under 5 years, there's insufficient basis for the parties to create a financial reliance on each other. Moreover, there's no showing whatsoever within the motion or underlying motion itself there's a need or ability to pay. My client provides her financial information showing that she makes $25.50 an hour working full-time. That would give her a gross annual income of $53,000. Husband number one admits to being voluntarily underemployed within his responsive pleadings, as well as he attaches as an exhibit an employment contract showing that at a minimum, he should be receiving an annual gross of $55,000. This is more than my client under her current salary. Again, husband's living costs could be easily paid for or beyond that if he was working an appropriate wage based on his experience. This is someone with substantial work experience that my client supported to go to school during the short-term marriage. He has an ability to either work in previous fields that he's worked at or use his expertise under his recent education to make what we believe way beyond $55,000. To the contrary, my client supports a child outside of this relationship full time, and she's been responsible for maintaining all of the household expenses during the pendency of this case. She's left in the negative each month. So again, this isn't a spousal support case. There's no need that we believe and no ability to pay. So we ask the court deny the request regarding spousal support. Similarly, these parties we believe should have identical incomes. If husband's interested in getting an appraisal, he should do so on his own. These parties just very, very recently purchased this home. So we believe that the value is not far off from what the purchase price was, and appraisals were done at that point. So again, my client simply just does not have the money to support husband's case. He should move forward with doing that if he's interested in doing so. We asked the court to deny his request for my client to continue to pay his auto payment and insurance. Again, these parties have identical incomes if husband not making more has an ability to make more. So we asked the court to deny that request. And similarly, we asked the court, this isn't a case that should have been brought on motions. The request, again, I understand as a pro se litigant, if he doesn't necessarily understand, but again, 99% of these requests should be made on a final basis. So we do ask the court to consider an award of attorney's fees.
Mr. Roshan, you get a chance to respond.
Okay. Can I have just a moment?
Sure.
Okay, thank you. So the standby Miss Gilmore says that there were 2 standbys. That's incorrect. There was one, and it was 15 minutes. I have submitted a list of my belongings to Mrs. Gilmore, or at least to Amanda. in my initial statement, and then there's more in my reply to Amanda's. More than happy though to put together a list of these items and send it to her. As far as when and if the time comes where I am granted to get my things, my children's things, if Megan Meese is not appropriate as a stand-in, then why not propose somebody else? Perhaps Amanda's mother, Irma Jenkins. And yeah, it does state in my contract that I'm supposed to be generating up to 55K a year. Well, I wish that's the case. This will be beginning of my third year with them, and I can provide documentation that shows that I haven't even made 50 grand my first year. It's we are COVID-19 and all of the goings on involving it completely turned the housing market upside down from what it traditionally has been. And Amanda and I, yeah, well, we didn't get married until just recently, 2019. We've been living together since 2015 for what it's worth. I think I'm just about done here. As far as, oh, here, yeah, the attorney's fees. So Amanda has just recently quit her job, her career at Weyerhaeuser. When that happens, as an ex-Weyerhaeuser employee, I know when you quit, when you're done working there, you're cashed out your 401k. And
I think that's speculative. I don't think that was contained in any declaration. I honestly, frankly, don't know the answer to that.
Yeah, that sounds like something that would be handled either at a settlement conference or a trial anyway.
And lastly, I've got my own attorney's fees that I've got to make payments on to the tune of $2,000. And I'm at my slowest point of the season, completely by myself. I'm fortunate enough right now to have friends that are gracious enough to let me stay in their home, rent free for the moment, but it's kind of starting to become an issue. What limited inspections I am getting right now, the income that I generate off of it has been going to putting clothing on my children. The same children that Amanda claims to love, that she sent out of our home just a handful of weeks before the holidays. I don't have any extra income, Your Honor. So I'd ask to have that denied. I think that's it.
Okay. Let me just ask a couple things that's in the proposed temporary order. It has Ms. Roshan with the Toyota RAV4 and Mr. Roshan with the Toyota Prius. Is that agreed by the parties? All right.
Yes.
All right.
Sorry, Your Honor, I was trying to pull up that proposed order. Do you have a date that was, it's a proposed order or just the motion?
I don't know if it was filed as a proposed order. Let me do this. Let me tell you what I'm going to do. I will annotate the order that I was given, and I'll scan it and I'll send it to you, Ms. Gilmore, to look at it. Okay. All right.
That's fine.
All right. So as to the personal property, I have heard this both at the protection order phase and here. It sounds like there's additional items such as a drawer of past due records, things like that Mr. Roshan needs. So Mr. Roshan, I'm going to require that you make a list of all of the items that you feel you still do not have and provide it to Ms. Gilmore by January 20th. And then Ms. Gilmore, I would like your client to make the property available to Mr. Roshan to pick up those items sometime on January 27th, 28th, or 29th. So that gives some flexibility as to time. I would like a third party to be present. Doesn't have to be the person who lives at the house. It could be a parent, step parent, somebody like that. I will say somebody that Ms. Roshan is comfortable with that can observe that. I'm going to give on whatever date is selected, Mr. Roshan, you'll have 3 hours to pick up these items. And if you feel you need some assistance because they're heavy or things like that, then I'm going to let you bring somebody with you, but I'm going to give you 3 hours. Otherwise, to me, it feels like you're just going to be there rummaging through the property, and that's what I don't want. I want you to go in, get the stuff you need, and leave. Okay. As to spousal support, I'm going to reserve that issue. I may make a decision on it at some time in the future, but I'm interested in Mr. Roshan getting his equipment and ramping up his work, and then we'll see if spousal support makes sense.
Could I say something?
Point. What's that?
When you're through, I'd like to go back to.
Okay, we can do that. Let me go through here though.
Okay.
I guess there's an auto payment and insurance. I would like Ms. Roshan, the wife, to pay through February. And then those items will transfer to Mr. Roshan in March. Again, I'm giving him 6 to 7 weeks to ramp up his business before he has to make those payments. Mr. Roshan can order an appraisal. And if he does, then Ms. Roshan has to cooperate with making the property available for it. Mr. Roshan will pay for the appraisal. And same token, if Ms. Roshan wants to do her own appraisal, then she can pay for her own. Okay. Attorney fees, I'm going to reserve at this time. Honestly, this is an ex parte docket where we typically don't have attorneys involved. So I'm not sure that, it would be an expectation of somebody like Mr. Roshan that he would have to pay attorney fees. But for right now, I'm going to reserve it. All right, you want to go back to the property issue?
Yeah, I was trying to scratch down what you were granting or about to grant here. So I'm supposed to make a list of these possessions, belongings of mine, my children's.
Right.
And have it submitted to Miss Gilmore by the 20th of March.
No,
January.
I said March, I made a mistake.
And then, yeah, that tied into my next question. Why is the pickup date in Jan? Okay, so anyway, the pickup dates will be arranged for.
Pickup date is the next week or the next weekend. And again, you can work with Ms. Gilmore to set those dates, okay?
And this is just to pick up work and tax related stuff?
Whatever is on your list.
Okay.
If there's a disagreement, then at this point, you're going to have to not pick it up.
if there's a disagreement, do not.
Pick it up because the court's going to have to resolve that disagreement. So the default is going to be where there's a disagreement, you don't get it.
Okay.
But it certainly as it relates to your work,
There won't be a problem. I'll make sure.
Work equipment and documents, I can't see where there would be an issue there.
Definitely not. The only thing I know for sure is an issue is some of the animals, but again, I'll try to coordinate the best I can.
Yeah, I know you want a particular chicken, I think, is that right? And, you know, if there's a disagreement about that, then
Yeah, that's my boy.
we'll have to reserve that, okay? What I'd like to do is, let's set a review of February 1. So that'll be after that pickup, and I just want to check in to make sure that went okay. And then I'm probably going to set another review. Looks like March 1. Just looking forward. I'm not going to do it right now because we need to see where Mr. Roshan's income is going and see how things are working at that time.
And my hope, honestly, is to have this set for a settlement conference as soon as possible. So that may not be necessary, but.
And I think that makes sense in this case. There's not that many issues. And
I agree with that also, Your Honor. Both of us, I think, just want to move on with our lives.
And, you know, depending on how it shakes out, I may be the settlement judge, so I'll know what is going on at that point. Okay. Or settlement commissioner. All right.
Thank you.
Okay.
Thank you, Your Honor.
All right. Thank you. Let's go.
Yes, please. Yes, please. Thank you.
Okay. Let me get to my notes on that. Mr. Raushan, were you able to retrieve your business items from the house?
Yes, Your Honor, and it's Roshan.
Roshan, thank you.
There were a few items that for what I don't understand why Amanda changed her mind on. My storage tank, the flatbed that we had, it's massive, Your Honor. It's 8 by 8 by 8 cubed, 2,500 gallons. Somebody filled it with water. So I had to pull the drain plug and drain it. And we ran out of time to load it onto one of our pickups. And now I'm being told that I can't have it back. It's $2,000. I missed my longer extension ladder to reach 2-story roofs when I inspect homes. And then also, I was denied any of my birds, any of them.
Any of your what?
My birds, my chickens.
Oh, your chickens. Okay.
Yep. That one specific little rooster. Yeah, that's a pet. She's already keeping both of the cats that I bought. If I could get some sort of a judgment from you off of those items, I'd say that's it, really.
Are you able to go about your job as a home inspector at this point?
Yeah, there are going to be a few that come up. I inspect primarily down in Vancouver, and there's different airfields down there. And when it comes to getting clearance for drone usage, sometimes it doesn't quite work, but for the most part, I'll be all right. It's just nice to have that 24-foot ladder when I need it.
Ms. Gilmore, do you want to respond?
Yes, I was trying to look back through my emails. My assistant has been handling the property transfer issue. And so I don't understand. I can't find the exact reason that my client disagrees to those transfers, but I know that there's a basis. The previous court's ruling was that if it was disagreed that it needed to remain with my client. And I think that we can deal with values and transfers of property on a final basis and any sort of judgments will either need to be agreed by the parties or determined by the trial court. So I just asked that there be no further rulings regarding the transfer of property. I think the vast majority of the property was transferred. There was, I would say, hundreds, if not thousands, of items transferred between the parties. So I asked the court make no further rulings regarding this.
The only thing that I'm concerned about is the extension ladder, which seems to be related to Mr. Roshan's work. I wonder if we could get that to him. And I think at this point, since there seems to be a dispute, the other issues, including the birds and the storage tank, are going to have to be addressed at the trial court level. But I guess again, I think that the extension ladder is going to be a fairly hefty expense if Mr. Roshan has to replace it. And I think that should be provided. Ms. Gilmore, do you think you can facilitate that?
So I just messaged my assistant, and she indicated that it wasn't the ladder itself that was the issue. It was that she doesn't want him to continue to be on the property because he allegedly was threatening her cousin. So that was the main issue. But if we can work to facilitate a transfer through a third party, then I think that would likely be fine. I understand the court's ruling. So I will try to facilitate that accordingly.
I don't want Mr. Roshan to go back on the property to get it. It needs to be provided to him somehow.
Okay, I'll get that done.
Could I say something, Your Honor?
Yes, please.
Yeah, I can have up to 4 witness statements that will verify that there was zero communication whatsoever at all capacity between myself, Megan, that's the niece, and I believe Bill Jenkins was also up there. They spent 90% of the time inside the house. And as far as the ladder goes, I think the best way to transfer this would be for Amanda to take that ladder and then drop it off at her mom's. My youngest daughter has started going over to the mother's house for visits. There's a young child in that house that she plays with, Amanda's sister's daughter. It's been going great. But if that ladder could just be dropped off there, that's a really simple solution to this.
Are you able to get in touch with Mr. Roshan, Ms. Gilmore, to
yeah, we'll get this done. I understand the court's ruling.
Okay. What needs to be done now in the future, other than, I guess, set this in front of the court for a resolution?
We need a transfer of some income information, retirement information, bank information, debt information. I was hoping to avoid a formal discovery exchange, but at this point, given the appraisal, I likely will need to at least do a pretty basic request. And then once I have that information, we can set it for a settlement conference.
Okay. Do you want me to set a review hearing to make sure that that information has been exchanged?
I don't think it's necessary, just to avoid additional costs of the parties and taking time off work.
Okay. So, Mr. Roshan, in order to move this forward, Ms. Gilmore is going to send you a request for various financial documents, which she will need, and both of you will need to go forward with this case. If you would like some financial documents from Ms. Roshan, you can send that request to Ms. Gilmore. Okay. So that's going to go on. When those documents are exchanged, then it's required that the parties set this for what's called a mandatory settlement conference to see if there can be a resolution to all of the issues. If there cannot, then it will go on and go to a trial. So that's going to be the next steps at this point. And I don't know that I'm going to set any more review hearings. I think all of that can occur outside of my involvement, unless for some reason either party feels that I need to come in and make a decision in the future. Okay.
Great, thank you.
Okay. Thank you.